Hello, my name is Paul Brampton. I'm a partner at IBB Solicitors. I'm also the Head of Construction and Engineering, and welcome to this webinar, which I hope you'll find useful. In the next 35 minutes or so, I'm just going to run through some of the main changes to the 1996 Housing Grants Construction and Regeneration Act. These changes were introduced on 1st October 2011 by Part 8 of the Local Democracy, Economic Development and Construction Act 2009. Now that's the last time that I'll refer to the legislation by their rather long-winded full titles. Instead, to keep things simple, I will refer to the Housing Grants Construction and Regeneration Act 1996 as the Construction Act and the Local Democracy, Economic Development and Construction Act 2009 as the new rules. So let's look very briefly at the content of this webinar. First of all, I will run through the background to the Construction Act and some of the detail. Then I'll look at the changes to the Construction Act brought about by the new rules, in particular the changes to the payment rules, the suspension rules and the adjudication rules. And finally, I'll wrap up with a summary of the key practical implications of these new rules. So let's get straight into the background. The Construction Act came into force way back on 1st May 1998, and as many of you will be aware, it was the legislative result of the 1994 Latham Report, Constructing the Team. The Construction Act applied to all written construction contracts entered into on or after 1st of May 1998 up to 1st of October 2011, when the new rules came into force. Whether a contract is a construction contract will very much depend on the nature of the operation being carried out and whether it falls within the definition of a construction operation. The question whether an operation is a construction operation is too detailed for this talk, but it is generally fair to say that most operations you would associate with construction work will fall within the definition of a construction operation, including the carrying out of construction work and the provision of professional services associated with that work, including both the design and the administration of a project. A notable exclusion from the definition of construction operations are operations where the primary purpose of the project is power generation, and also contracts with residential occupiers were excluded from the Act as well. And as I've indicated on the first bullet point there on the slide, Section 107 of the Construction Act provided that the Act only applied to construction contracts which were in writing, but as we will see on the next slide, this is one of the things which has been repealed by the new rules. So historically, the Construction Act was introduced to tackle endemic problems with a lack of cash flow in the industry, and some of the hardest hit by cash flow problems were smaller companies. What the Construction Act did was it gave payees a statutory right to interim or stage payments where the duration of the work was specified or estimated to be greater than 45 days, and it required all construction contracts to state clearly what would be paid and when. The Construction Act also gave the payee the right to suspend all of the works by reason of the payer not making payment, and the Construction Act outlawed pay-when-pay clauses, that is, clauses which make payment conditional on the payer receiving payment from the third party. The Construction Act was also introduced to address the problem of protracted and expensive delays which were affecting even the most straightforward construction disputes, and it did this by introducing for the first time to the UK shores the concept of a statutory right to refer disputes to adjudication, which, as many of you will be aware, allows for rapid resolution of disputes by a third-party adjudicator in 4 to 6 weeks and provides a decision which is binding on the parties until the dispute is determined by the courts or by arbitration, or until the dispute is settled by agreement between the parties. After what has been a long period of consultation, it was decided that the new rules would affect most parts of the Construction Act. As mentioned on the previous slide, the Construction Act only applied to written contracts, whereas the new rules apply to oral contracts too. This change has been brought about by the repeal of Section 107 of the Construction Act, which provided that the Construction Act will only apply to construction contracts in writing. And it's just worth mentioning here that a practical implication of this is that it's highly likely that more witness evidence will be required in adjudications, and indeed more adjudication hearings will be required in order to test that witness evidence so as to establish what the terms of the contract are, even before the adjudicator can start to consider the merits of the dispute itself. Now, this is going to put adjudicators under massive pressure to successfully conclude adjudications in the necessary 4 to 6 week timetable, and it will also make those adjudications more time consuming and costly to resolve. So as far as the rules themselves are concerned, very few aspects remain totally unaffected by the new rules. As we shall see, the payment rules at sections 109 to 111 of the Construction Act have changed quite significantly, as have the suspension rules at section 112, and the adjudication rules at section 108 have also changed. The pay when paid prohibition at section 113 of the Construction Act is not affected, although a raft of additional prohibitions have been introduced by amendments to sections 109 to 111 of the Construction Act. And it's worth reminding ourselves, as noted there on the slide, that in England and Wales the new rules came into force and apply to all construction contracts entered into on or after 1st of October 2011. In Scotland, the Act doesn't come into force until 1 month later, on 1st November 2011, although for the remainder of this webinar we'll only look at the situation in England and Wales, not how the Act is being enforced over the border. Now it's just worth pausing there to quickly consider two of the immediate practical implications of the new rules which came into force on 1st of October 2011. Firstly, in relation to framework agreements, there are of course a lot of construction operations carried out under framework agreements these days, some as a result of European procurement regulations. So it's important to look very carefully at your existing frameworks, because where contracts are called off under existing frameworks after 1st of October 2011, those contracts will be governed by the new rules, not by the legislation which applied when the framework agreements were first entered into. So parties need to take a careful look at the form of the construction contracts for which provision is made under their frameworks, and if those contracts aren't compliant with the new rules, then the parties should look at how they need to change the contracts to make them compliant. Now, legal practitioners have been aware of the new rules for some time, so it may be that your frameworks have been drafted with both the old and the new regime in mind. Nevertheless, it is worthwhile having them checked out. The other practical implication relates to larger projects where the project contracts have been let on or around 1st of October 2011. And the issue here is that on some of the larger projects where there are a number of different construction contracts relating to the same project, then some of those contracts would have been entered into pre 1st of October 2011 and some will be post 1st of October 2011. Therefore, it's entirely possible that contracts, subcontracts and professional appointments under the same project will be governed by two different statutory provisions, and care will therefore need to be taken to administer and enforce those contracts in different ways. So if we can look in a little more detail now at the changes brought in by the new rules, first let's look at the payment provisions, and in particular let's look at the payment practice prohibitions which were brought in by the Construction Act and have now been expanded by the new rules to limit payment practices which prevent subcontractors from being paid for reasons which are outside their control. Firstly, there's the prohibition against pay when paid clauses. Now, as I've already mentioned, Section 113 of the Construction Act contained a general prohibition against pay-when-paid clauses, that is, clauses which make payment under a construction contract conditional on the payer receiving payment from a third party. The purpose of Section 113 was to put the brakes on the once widespread practice where a subcontractor might not be entitled to receive payment because the contractor hadn't received payment from his employer, perhaps for reasons completely outside the subcontractor's control or influence. As noted on the slide, Section 113 does contain an exception, which is that a pay-when-paid clause can be effective where the third party is insolvent, for example, where the main contractor's employer is insolvent. So the new rules don't amend Section 113, with the result that the prohibition against pay-when-paid clauses remains as it was, but the new rules introduce a number of additional restrictions. Moving on to the second bullet point on the slide there is a new prohibition against pay-when-certified clauses introduced by new Section 1101A. Now, pay-when-certified clauses were commonly used to make payment under one contract conditional on the performance of obligations or the making of decisions under another contract, and was deployed by a number of payers as a ruse to get around the prohibition against pay-when-paid clauses. Now, there is an exception to the prohibition against pay-when-certified clauses, and that is set out at Section 1101C. The primary purpose of Section 1101C is to prevent payment provisions in management contracts between the employer and the management contractor from falling foul of the new rules. This is because payment to the management contractor, who doesn't himself carry out any construction operations, will generally be linked to the performance of obligations by the trade contractors under their trade contracts. Now, although it's not mentioned in the new rules, it's also intended that PFI subcontracts won't be subject to the prohibition against pay-when-certified clauses, and this is set out in the Draft Construction Contracts England Exclusion Order 2011, which also came into force on 1st of October 2011. So just to be absolutely clear here, the Construction Contracts England and Wales Exclusion Order 1998 set out a number of types of contract which were not caught by the Construction Act, including PFI project agreements between the public body and the PFI contractor. However, PFI subcontracts, that is those between the non-public PFI contractor and a subcontractor, were bound by the Construction Act and remain bound by the Construction Act as amended by the new rules. So the sole purpose of the 2011 exclusion order is to exempt those PFI subcontracts from the prohibition against pay-when-certified clauses at Section 1101A. And it should also be noted that the 2011 exclusion order won't apply to Wales, although it seems likely that similar exclusions will be made for Wales and Scotland. So just moving on to the final bullet point on the slide, there is now a prohibition against pay-when-notified clauses in construction contracts as well. So just by way of background, under the old regime, employers sometimes tried to contractually delay the due date for payment to avoid their obligations under the Construction Act, and they did this by providing that the due date wouldn't commence until they, the payer, had given a payment notice to the payee. In other words, you'll get paid when we notify you that you will get paid. So what new Section 1101D does is outlaw any payment procedure where the payer or third party decides when payment is due. Finally, it's just worth noting that although these prohibitions go some significant way to improving cash flow down the supply chain, by prohibiting payment practices which link payment down the chain with events higher up the chain, the new rules don't seek to tackle or prohibit the common practice whereby the payment periods get gradually longer as one moves down the chain. And this was a point which I suspect went to consultation, but it is difficult to see how legislation could interfere with the length of payment periods themselves, given the enormous variety of construction contracts out there. So I'll move on to payment itself now and the changes which are being made in relation to that. The changes are quite dramatic in that the new rules repeal section 1102, which deals with payment notices, and completely replace that section with the new payment notice regime set out under section 110A and section 110B. So on this slide we're just going to look at section 110A, which is much the same as the repealed section 1102, although there are a number of important differences. The requirement to issue a payment notice no later than 5 days after the due date remains. However, the key difference is that the payment notice can now be issued by 3 categories of person. The payer, as was the case under section 1102, but also the payee or a specified person can now issue the payment notice. Now, the specified person will be that person identified as such under the construction contract and will typically be the contract administrator, for example, an architect, engineer or project manager. And as was the case under the repealed section 1102, the payment notice itself must still specify the sum that's considered to be due and the basis on which that sum is calculated. And finally, section 110A clears up the previous ambiguity under section 1102 and expressly provides at section 110A4 that a payment notice must still be given even if it's considered that the payment due is 0. So moving on to look at section 110B, quite significantly the new rules have introduced an entirely new concept of a default payment notice, which is a concept which didn't exist at all under the old Construction Act. So if the payer or the specified person fails to issue a payment notice by the specified deadline, then the payee can now issue a default payment notice in its place at any time after the specified deadline for the payment notice. Now, if a default payment notice is served, then the final date for payment is deferred by the period of delay between the date when the payment notice should have been served and the date when the default payment notice is served. So it's just worth flagging a practical tip for payees here. In the absence of a payment notice, the payee should serve the default payment notice promptly so as to crystallise the final date for payment as soon as possible. Finally, on this slide, it's also worth mentioning that section 110B4 recognises that the payee's application for payment may itself amount to good notice. So in practice it may be that the default payment notice will rarely be relied upon. But it should be noted that if the payee's application for payment amounts to a good payment notice, then the payee can't also give a default payment notice, and indeed there would be no obvious reason to give a default payment notice anyway. So section 111 of the Construction Act set out the requirement that a payer must give a valid withholding notice if he proposed to withhold all or any part of a sum that had become due, and that section has been entirely replaced by a new section 111, which performs a very similar role to the previous section 111, although it's termed a pay less notice under the new rules. But significantly, what new section 111 does first of all is introduce the concept of the notified sum, which is the sum referred to in the payer's or the specified person's payment notice or in the payee's default payment notice. This is the sum that's to be paid by the payer unless a pay less notice has been given by the payer or the specified person. So if the paying party or the specified person doesn't consider that the notified sum is properly payable, he will need to give a pay less notice in order to be entitled to pay less than that notified sum. And that notice must be given not later than the prescribed period before the final date for payment in order to have effect, which will probably sound very familiar to those of you who've served or received withholding notices under the old regime. So the really important point to remember here is that the pay less notice is a responsive notice, and by that I mean that a payer or a specified person can't give an effective pay less notice unless there's a notified sum by virtue of a payment notice or a default payment notice. So is there any real difference between a withholding notice and a pay less notice? Their effects similar, but there are some important differences that you will need to think about, particularly in the early days when you're preparing your contracts and putting payment procedures in place to comply with the new rules. As noted there on the slide, pay less notices must specify the amount that the payer considers due on the date that the pay less notice is served, which might be 0, and the basis on which that sum is calculated. And by way of comparison, unlike the withholding notice, a pay less notice does not specify the amount proposed to be withheld and the ground for withholding. It's also worth pointing out here that the Construction Act allowed the paying party to combine the payment notice with the withholding notice. However, that facility is not available under the new rules. Under the new rules, the paying party must serve a separate responsive pay less notice if it proposes to pay less than the sum notified in the payment notice. And I must say, it seems highly likely that after the new rules come into force, that there will be a number of disputes as to what constitutes a separate notice. So for present purposes, I think the practical tip to payers and specified persons must be to ensure separate documents under separate cover are served, and to set up your payment systems accordingly in order to do this properly. Finally, while we're still looking at payment under the new regime, I'd like to look at one of the more significant changes which provides that oral contracts will now be covered by the legislation, with the result that after 1st of October in England and Wales, the Act will now apply to all construction contracts, whether in writing or wholly or partly orally concluded. The practical effect of this is that if there's an oral contract which doesn't include payment terms which comply with the amended Act, then the payment terms will be implied into the contract by the statutory provisions set out in the government scheme for construction contracts. And it's hard to imagine many oral contracts which will contain sufficient detail to comply with the detailed provisions of the Act, and therefore it seems that most oral contracts will be subject to the statutory payment provisions as set out in the government scheme for construction contracts. So that now deals with the main points in relation to payment. So let's move next to the changes to the rules on suspension. The right to suspend is in effect a self-help remedy designed to allow payees to apply pressure on payers that haven't paid in full by the final date for payment. The Construction Act provided a right to suspend at section 112, but these rules have been amended by the new rules in 3 key ways to give the rules more teeth. Firstly, under the Construction Act, a pay could only suspend all of his obligations to perform under a contract where he hadn't been paid in full by the final date for payment. So it was an all or nothing right, and in practice, payees proved reluctant to completely demobilise especially where they had existing obligations to their own subcontractors. So to that effect, the Construction Act was quite ineffective, with the result that the new rules set out to tackle the problem by making it clear that the payee may suspend part or all of its obligations under the project if the notified sum, subject to any pay less notice, isn't paid in full by the final date for payment. Moving on to the third bullet point there, the wronged payee is further protected by new section 1123A, which expressly provides that the payee is entitled to claim from the payer the cost and expenses incurred by the payee by reason of the suspension, and this will extend to the demobilisation and remobilisation costs, the intention being that the wronged payee shouldn't be left out of pocket by operating his right to suspend. And finally, section 1124 has been amended so that the payee shall be entitled to an extension of time for any delay caused by a suspension, not just the period of suspension itself. Therefore, the extension of time should cover both the demobilisation and the remobilisation periods. So those amendments to the suspension rules are, I think, fairly self-contained and easy to understand, which takes us on to the amendments to the adjudication rules. As previously mentioned, under the new rules it will be possible for the first time to adjudicate disputes on construction contracts which have arisen wholly or partly by oral agreement. So is this a good thing or a bad thing? Well, on the positive side, time-consuming and costly jurisdictional arguments about whether the contract's in writing, and therefore whether the Construction Act applied to the contract, have been closed down by the new rules, which apply the Construction Act to both oral and written contracts. But the negative side of all this is that there's clearly massive scope for dispute as to what the terms of oral contracts are. And the adjudicator is going to have a formidable task on his hands construing the terms of an oral contract before he even gets to the point where he can consider the merits of the claim itself. And this could render the 28 to 42 day period for the adjudicator to reach his decision as very difficult to achieve, and the need for expensive adjudication hearings where witnesses can be tested on their evidence are unfortunately likely to become more prevalent. So the practical advice here must be to continue to take great care not to allow oral contracts to come into being. So moving on to the second bullet point there on the slide, and despite the fact that construction contracts subject to the legislation can now be oral, unless all of the 9 adjudication requirements of section 108 subsection 2 through to subsection 4 are set out in writing in the contract, I repeat, in writing in the contract, then the scheme adjudication rules will apply. So, by contrast, unlike the payment provisions, it isn't enough that the 9 requirements might have been agreed orally. Now, the 9 requirements to be included in writing in the contract, broadly speaking, describe the adjudication procedure and the scope of the adjudicator's power. And unless they're included in their entirety, the whole mechanism is tainted and falls by the wayside to be replaced by the government scheme. Now, I'm not going to run through the detail of those 9 requirements here, because the requirements remain largely as they were under the Construction Act anyway, but there is one significant change which we'll look at on the next slide. So one of those 9 requirements which must be written into the construction contract is the express right for the adjudicator to operate what many of you will be familiar with as the slip rule. That's the rule that gives the right for the adjudicator to keep his appointment open for the purpose of correcting his decision to remove obvious clerical or typographical errors. Now, although operation of the slip rule has over the past 13 years come to be generally accepted by the courts and by legal practitioners, it wasn't formally recognised by the legislation, so this has been done by the new rules, which is only to be welcomed. Moving on to the second main bullet point there, section 108A now addresses some of the concerns around who should be liable to pay the adjudicator's fees and expenses. Historically, the Construction Act remained silent as to who should bear the cost of adjudication. Therefore, there was free rein for the parties to reach agreement at any time as to who might be responsible for the costs and expenses of adjudication, with the result that bigger companies would sometimes take unfair advantage of their bargaining power by including unfair provisions that the other smaller party would pick up the fees and expenses regardless of the outcome of the adjudication. These types of clauses came to be known as tollant clauses, named after the case that went to the Technology and Construction Court, Bridgeway Construction versus Tollant Construction. And although they were generally recognised as an unreasonable constraint on one of the parties to adjudicate, such clauses did not strictly offend the Construction Act. Section 108A tackles this by outlawing any clause which seeks to determine in advance who will pick up the cost of adjudication. There are only two exceptions to this. Firstly, a construction contract can legitimately state that the adjudicator shall have the power to decide on the allocation of his fees and expenses, nothing too surprising there. Secondly, a written agreement regarding the allocation of fees and expenses will be upheld if made after the adjudication has commenced, although it's difficult to imagine that this will occur very frequently in practice. It's probably just worth noting at this point that a number of commentators have expressed concern about the quality of the words composed by the parliamentary draftsman at section 108A. The specific concern relates to section 108A(2), which says that a cost allocation provision is ineffective unless it confers power on the adjudicator to allocate his fees and expenses. The specific concern being that a provision which makes one of the parties responsible for the other side's legal costs would be effective, provided that it also confers a power on the adjudicator to allocate his fees. Now, in our view here at IBB, it's an artificial reading of the legislation, because an ineffective clause which allows costs doesn't become effective because it sits alongside an effective clause conferring a power on the adjudicator to allocate his fee. Nevertheless, it wouldn't surprise us if we see some adjudication activity around the correct interpretation of section 108A, with some parties seeking to enforce provisions which entitle them to be awarded their costs regardless of outcome. Therefore, in conclusion, my recommendation to you would be to avoid including tollant-type clauses in your contracts. The Technology and Construction Court are very likely to take an extremely dim view of them, with the result that such clauses will be struck down together with the other adjudication provisions in your contract to be replaced in their entirety by the government scheme. So in conclusion, let's recap on the practical implications of the new rules. Firstly, remember to reflect the new rules in your contracts. Make sure you use the correct terminology and make sure that you adopt the correct processes, otherwise you may have terms imposed on you by the statutory government scheme for construction contracts. And also be aware of the outlaw provisions in relation to contractual agreements regarding adjudication fees and expenses, and the now longer list of prohibited payment practices. So we now have pay when paid clause prohibition, a pay when certified prohibition, and a pay when notified prohibition. And as a further footnote, ensure that all 9 adjudication requirements are set out in writing in all of your construction contracts. Moving on to the second bullet point, unless your contracts have been prepared by a construction lawyer, it's a good idea to adopt the latest revision of a standard form, as these will properly reflect the new rules. By way of example, the JCT 2011 suite was published on the 9th of September, and it includes amendments to deal with the changes to the Construction Act. It's also probably just worth mentioning that the existing 2009 version will be completely withdrawn in July 2012, but it will have been out of date for 10 months by then anyway. In the same way, NEC and the other standard forms have published amendments to their contracts. Moving on to the third bullet point, adapt your systems so as to respond to the two-stage payment process that is, in particular the need for a payment notice and a separate pay less notice. And remember that you can't combine the notices, they must be separate documents under separate cover. And if you're a payee and a payment notice hasn't been given by the payer or the specified person, then be ready to give a default payment notice swiftly. If you're a payer or a specified person, you need to make sure that the drafting of your notices reflect the subtle changes brought in by the new rules, including the need to include a zero amount in the payment notice if applicable, as a failure to do this will entitle the payee to issue a default payment notice. And remember that pay less notices must specify the sum due, not the sum being withheld, which again I emphasise can be zero. And finally on this point, remember that failure to give a payment notice and a pay less notice will entitle the payee to the full amount which has been applied for. Moving on to the fourth bullet point on the slide, if you are an aggrieved payee, make use of the new rules. Be aware of the enhanced suspension rights, that is the right to suspend all or part of the works, and the right to claim loss and expense and extensions of time which now flow from that enhanced right to suspend. And moving on to the fifth bullet point, take care not to allow yourself to enter into oral contracts. Adjudication is a summary procedure, and adjudicators are going to struggle if they have to decide what the terms of the contract are, even before deciding the dispute itself. So make all pre-contract communications subject to contract to avoid unwittingly creating contractual relations. And just to cover the final three bullet points there on the slide, remember that all contracts entered into on or after 1st of October 2011 in England and Wales must comply with the new rules. This will include all construction contracts called off under existing framework agreements, even framework agreements entered into before 1st of October 2011. And be careful on the bigger projects where some contracts and appointments will be subject to the old rules, and some of the contracts entered into after the 1st of October 2011 will be subject to the new current regime. You'll need to manage those projects carefully because the operation and enforcement of the pre-October contracts will be completely different to the post-September contracts. Okay, so that brings this webinar to a close. I hope it's been useful. Please feel free to contact me or any other member of the IBB Construction and Engineering team if you have any concerns about contract amendments under the new rules, or if you feel that you need advice on how you should go about amending your payment procedures and the content of your payment notification certificates. Thanks very much for listening.